Admission, my lord, my pardon to mention that in spite of the recommendation of the commissioner, the DO and BO have not taken any steps to join the petitioner. The petitioner is in service, but she did not avail the holidays for which she has represented to the authorities since long. She is a lady, my lord, and she is at the verge of retirement, my lord. Only a fresh admission may come next week.
Immediately after vacation,
My lord, if a notice will go before vacation, next. Grateful, my lord.
Yes, admission. With regard to the area salary, already matter is pending next week here also. With your lordship's permission, weekly list item 163.
163.
And this matter where the petitioner has already obstructed the road, which I am not able to approach my house, which is half constructed. The lordship heard the matter and directed to produce the cell deed. With regard to the cell deed, in last order was, if your lordship will not produce the cell deed, that will be negative inference.
Yeah.
Can it be next week in supplementary list? I pray, my lord. Do you have urgent matter?
You have got the cell deed now.
No, I am for the opposite party. I am the sufferer. 2 orders passed against him, my lord, by the competent authority, building authority, my lord. Eviction order was passed. Due to the order of status quo, demolition cannot be carried out. One portion is carried out by the other person who has obstructed, and another person has not been obstructed. Before this honorable court, obtain the order of status quo.
But we'll have it off immediately after vacation.
Let's see, after vacation in the supplementary list, my lord.
After vacation, put in.
Put on 9th, my lord, supplementary list.
My lord, this is the arbitrary transfer order matter. So the petitioner challenges the frequent transfer order made on 25th July and 31st July, which causes harassment to her. My lord, may it come on Monday.
Next week.
The lordship's permission, my lord. Item 91 of the weekly list, my lord. A student is involved.
Student is.
My lord. Recruitment matter. Yes.
Recruitment.
Yes, my lord.
But how student recruitment relation?
He is continuing his studies, ma'am.
He is continuing studies. What's the urgency? He is continuing studies.
He has completed his studies recently, madam.
Completed
Yes,
the course.
Yes, madam.
Which course?
Art, bachelor in arts, madam.
B.
Art theory, madam.
What?
Yes. My lord, he has secured more marks than many of the selected candidates of the select list, my lord. But his case has been rejected by the authorities. And in the meantime, the appointment orders have been issued to other students, other candidates.
No.
So, if your lordship permits any date next week, then
Next week we have difficulty for that. A week after next immediately after vacation.
it can be disposed of within 10 minutes, my lord.
That's why.
Pleading salary.
Two cases take 10 minutes. There are no case on the multi cases in this court. Immediately after.
Item 62. The career of a student is involved. The result has not been published by the CBSE because of the revolution. Now he is selected for BTech admission. Can it be taken up today?
62.
82.
82.
Yes, in the weekly list.
In the weekly list.
Yes.
Who is your opponent?
Yes, Mr. Patnaik, I have informed. If my lord allowed me, then I will inform him. He will come. Definitely.
Ask him to come by 12.
Yes, any convenient time.
Just come, let us.
Yes.
Let us.
Item 1.
Immediately.
Yes.
The petitioner was appointed as a lecturer in political science on 8th December 1999, I think. At the time of this appointment, the institution status was an honorable recognized institution. The institution was notified as an aided educational institution on 6th March 2018.
2018.
6th March 2018, institution was notified as aided education institution. Thereafter, my lord, 31st March 18, the appointment of all teaching and non-teaching, including petitioner, was approved for the purpose of release of salary.
Approved on
31st March 18. On 26/4/18, petitioner was approved as a principal in charge cum secretary of the institution, being the senior most teacher of the institution by the director on 26/4/18. After the institution was notified as an aided institution, on 29th October 2022, the governing body was reconstituted as per Rule 25 of the Management Rule 1991. The term of the governing body is 3 years from the date of its approval. While the governing body was continuing, 23rd of December 2024, state government passed an order by dissolving all the governing body of the state.
Yeah. That was with effect from?
with effect from 23rd of December 2024.
And it took over the management.
Yes. Madam?
Government itself took over the.
Government said that all the governing bodies stand dissolved and only sub-collector was allowed to continue as a president of the governing body for a temporary period, and direction was given to authority concerned to take a decision for take steps for reconstitution of governing body.
Yes.
Madam, while matters stood as though, and so-called notice was issued by the opposite party number 4, Annexer 8, indicating himself that as the president of the governing body. My first ground, my lord, to challenge that the person who has issued this order is not the competent, because as per Rule 21 of 74 rules for my lord, C4 moment, the disciplinary authority is the governing body that has been prescribed in Rule 21 of 1974 rules.
But this is issued by whom?
This is issued by the president of the governing body, who was not approved president of the governing body, because governing body is a period of continuing a period of 3 years from the date of its approval.
But you show that cost to him.
No, my lord, what are the 2 grounds? I'm saying 2 grounds. There are 2 grounds. First ground, my lord, that the person has not authority to issue such type of order, has no jurisdiction, which has been decided by this Hon'Ble Court in series of cases, my lord. And so, the second ground, my lord, if it will accepted for the sake of argument that yes, he has some authority, in that circumstances, my lord, when he issued notice Annexer 8, granting me 7 days time to give a reply. My lord, kindly see the page 8.
When it reached you?
My lord, page 31, kindly see.
No, when it reached you?
I received in time, my lord. I received in time. This notice said that notice was issued on the basis of some allegation. I immediately, the date when I received, next day I wrote a letter that you supply those documents which was on the basis of which so cause has been issued. Annexer 9, page 33, my lord. Now he said, Annexer 10, page 34, last but 1 paragraph, that in this regard it is clarified that you are not authorized to seek or demand a copy of the inquiry report or letter of allegation, as these are internal document of the governing body. First of all, governing body is not there, my lord. This is also violating Rule 22 of 74 rules. 74 rules clearly says if a document is called for, it is supplied.
Kashinath Dixit case.
I have obtained that Kashinath Dixit, my lord. Yes, my lord. Para 12, my lord.
All documents have to be furnished in months.
But so far the authority concern, I have got the.
Sorry.
When judge himself is.
Sorry, my lord. No, I will just supply. Sorry.
Yes.
So far the.
Unless these documents are given, how he will be able to prepare his defense? Only 1 line defense it will be. I am not able to take defense because you are not supplying the documents. Drop the proceedings.
But so far the authority is concerned, that is there.
Let's say, let us. We'll
So far
assume
this
that
non-supply is concerned.
correct. We'll argue. But without documents, the apex court said long ago, Kashinath Dixit is not a fresh law. That is law since 1967. Therefore,
Yes,
till you furnish the document, you don't take any action.
or it's remanded back, giving an opportunity to supply the document within a time frame.
Where is the question of remanding back? We're disposing of that matter till you supply the documents. Don't. You can't ask him that Dhakeshwari cotton mills versus wines, which Jain and administrative law elaborately discusses. Very easy to remember the name also. There they say, without documents, you cannot take any decision. You should furnish the document. Of course, it was a matter relating to some other work of law. But in the Kashinath Dixit, they said without giving documents, you cannot take action. You give document, hold inquiry, hang him to the nearest tree if your rules permit. Well and good.
But my lord,
Issue a moment.
yes, no, my lord.
A lawyer should know
No, what to stop?
where to stop.
My lord.
very important case. Issue emergent notice. Learned ATA accepts notice for office. All office.
All, my lord.
Next question. An application supported by affidavit in IA number so is moved for halting the contemplated inquiry on the ground that the documents necessary for taking up the defense have not been furnished. And therefore, petitioner is not in a position to formulate his defense. First, counsel for the petitioner presses into service the apex court decision in Kashinath Dixit versus so-and-so, or so-and-so versus Kashinath Dixit. But
Kashinath Dixit versus Union of India.
Union of so-and-so. Take that too. There is force in this submission. Next paragraph. There is force in this submission and matter requires deeper consideration. Next paragraph. In the above circumstances, the subject inquiry is halted till next date of hearing. Okay. Call this matter in the last week of October.
Item 2.
Yes, Mr. Dash.
In this case, though I have already filed a written note that check some compilation of text, I have given it here. Here the point of law involved.
Make brief statement of the case.
Yes, just I have given it. I have given 3 judgments only, and one of the judgment I am obliged to my lord. My lord, I have given 1 judgment.
No, not that. Do you know there was one Louis Brandeis?
Yes.
In the US Supreme Court.
Yes, Supreme.
He was a great lawyer. Many biographies are available. Thereafter, he became a associate judge of the Supreme Court. He used to coin the brief statement of the case within 30 seconds, because in American court, you cannot go on arguing till the cows come home. They will allocate time period for you, which our apex court said in LIC of India versus Escorts Limited. Justice Chinappa said it is high time. That's fixed time for all argument, judgment, the lawyers to argue.
Now that was developed in
Brandeis statement.
Yes.
What is that case?
My experience, just before starting, my experience was I have started the practice when my lord Justice Ansari was the Chief Justice here. He used to say, if you cannot satisfy in 1 line the judge, then you cannot satisfy within 1 hour. So therefore, you have to state the case in 1 line or 2 line, whatever.
Yes.
So my lord, case is, a person was terminated. He was to file an appeal before the appellate authority, that is under the government circular, before the director. So he filed an departmental appeal because this is an order distribution. Instead of, he has filed an appeal, but thereafter, appeal was kept as such. She joined in somewhere else. When the institution became eligible to aid, and I was the person concerned continuing against that post. So then when the grantee and all this thing came, he came up and made out a story that I was terminated in 2000. He was resigned and terminated in 2000. In 2007, I have terminated. She came to another appeal, filed an appeal before the State Education Tribunal. Unsuccessful because the State Education Tribunal says your appeal, administrative appeal, has to be decided first. Suppressing that order of the Education Tribunal, has filed a writ petition before my lord. And my lord, without knowing of these facts, directed that you go to the another person, another director, to decide your appeal. And that director passed an appeal without looking into any readings, any document. And that order is before my lord. And in that order, what the director has held, a peculiar order, my lord. In one hand, said that the person will be reinstated, a termination in 2000. In 2023, 24, he has passed that order. But he said that my appointment is void, necessary, bona fide. And I have to continue. Director, Higher Secondary Education. So with this
I am the petitioner now, before my lord.
Yes.
So-
Who is your opponent?
My lord, senior Mr. is for the private respondent who has filed appeal. No, ठीक है, move कोई sir again. That is your problem. Move, let me complete. No, I will complete very short time.
The Lord is asking, who is asking? I'm
And what you oh, yes, I stated you are there. Please wait.
Saturday sitting, na?
The problem is well.
Yesterday.
We have habit not to come on Saturday. That is the cause of it.
No, my intent is well. I have some cases because on Saturday we have cases in Bhubaneswar. That is off day here. I have many cases there. I send my associates there to I have to complete and I have to go. That is my problem. So I will complete it in no time, my lord. So whatever I have stated, my lord, I will only show this compilation.
You ready in the matter?
Yes, sir.
Yes.
This is the compilation what I have filed, my lord. Everything is there on record because this is the volume. Kindly see the volume, my lord. This is a quite voluminous document. Everything is there, but I will show this, whatever I have stated, I will show it from that document first. Now, my lord, kindly come to, I am sorry, my lord, it is in a hurry. I have prepared this.
No problem.
I could not make page mark.
Your preparation, hurry in preparation, all right. But hurry in argument.
No, I will not be hurried. I will not be hurried. But I will be precise as my lord have told me.
Yeah.
My lord, kindly see the text here. There is a type mistake in the first page itself. My lord, 7896, that will be, my lord, I may
7896?
7896 is all.
I will rectify.
That is a mistake, my lord.
No problem.
7896. The opposite part number 4 was, shall I read it, my lord, or I will place the without reading it?
Yes, whatever is convenient.
Yes, my lord, let me read out, madam. Just one line, I will just touch it.
Yeah.
The opposite part number 4 was appointed on 7896 as a lecturer in English of the OP number 3 college. The college. And she has admitted that is the admitted case in her appeal also. Enrolled in PhD program in Barampur University in December 1996.
December, that is 4 months after appointment.
Yes, immediately. She has enrolled. But she has got the permission from the principal of the college to go undergo such training only on 28/7/97.
Yes.
Again, and she was allowed steadily for the purpose from 1/7/2003 to 31/5/2005 initially, thereafter extended up to 31/12/2006.
1 second. She would undergo PhD program with effect from 28/7/97.
No, that is the permission. 96, December 96 enrolled. She is her case.
The enrollment is 96.
96,
For
December, PhD. Without permission, she was enrolled. But subsequently got permission, he says.
Yes.
28/7/96. My case is, well, all these are the manufactured document. Prepared document. Fabricated. These are what are we doing from that also? My lord, here, my lord, the law is in this paragraph. If the PhD program of the universities, as per the UGC regulations, is 6 years maximum, 3 years is the first initial duration. If somebody failed to submit the thesis and all,
Minimum duration.
so 6 years. And there is a maximum further 2 years can be granted in a special circumstances if the syndicate desires so. So totally 8 years, my lord.
So
now
normal is 3 years.
3 years. Extended period is 6
Extended
years.
period is another 3 years.
3 years.
Then grace period is 2 years.
So 8 years. So if my response submission is if she had enrolled herself in 96,
December 96.
she had to complete it in 2004, 8 years. Even if she got the grace and all these things, 8 years. But it is her case, she has completed in 2006, which is not permissible in law also. This is one aspect. So my case is also not that far, but this is the law. Now,
She completed her PhD.
yes, she has completed yesterday.
She completed PhD when?
She says it is 2006. No document is there, but let us admit that 2006 she has completed.
You will admit that she did it.
She did it.
Can you give the date? Just date. PhD.
It is not given a document.
No document is given. I'll just find out.
Just find out.
He said somewhere, well, February 2006. No. February 2006.
And thereafter resumption in duty on 20th January 2007.
Yes.
After completion.
So that is PhD.
Yes.
21 2007.
Yes, I have stated so.
That is the resumption of duty.
Exactly.
2/1/2007. 2-1. Now, madam, I have stated, so need less to mention here that as per the law, duration of PhD course is 6 years. Since then, the case of the author, she has enrolled PhD in 96, she has to complete from 2002. Therefore, the great grant of study leave beyond 2000, that is from 2003 to is under cloud, and hence the manipulation.
She came back to duty on
Her case is, she came back to duty on 2/1/2007.
yes.
And her case, further case is, she was not allowed to join duty on prevented on 21/2007.
Yes.
That is why she had filed an appeal before the Director of Higher Education Orissa on 31/2007. This is the appeal. That appeal is there, madam.
Appeal number 11 of 2000.
No. That is an administrative representation. My lord will file it at Annexure 1 of the writ petition. I have given it.
Annexure 1.
I have also compilation, page 28, my lord. I will read out the case because that lies the crux of the issue, my lord. Because 3 appeals he has filed before different forums, the contents I will show. Grievance petition of reinstatement of my service. Shall I read, man? Annexure 1, page 20. To the Director of Higher Education Odisha.
Study leave was from 1 July 2003
to 2005.
31 May 2005.
And she was extended up to last of the year. Then they stated that. But when he come back, join, on January 6th, it did not allow him to join and continued my service. Next page. When I came back college, joining my duty in month of January 2007, but the state secretary did
No, did not permit
to join.
Right? He demanded 10,000 rupees, sir.
Yes, 10,000 and all these things. And appeal is filed, date is below, my lord, 31/2007.
Yes.
So now, my lord, this is the case at the first instance. The prevention or termination is 21/2007. And the appeal is 31/2007. It is within 30.
Where is the termination?
The termination and prevention amounts to termination. That is his case here. Her case in this appeal.
Suppose if an employee is prevented from resuming the duty after coming back, does it amount to termination?
No matter the judgment of our own High Court is, if amounts to, if a lawful prevention, I have a right to terminate him, but without termination order I prevent him, then amounts to termination. That my lord have.
Industrial law.
Yes.
Service
Maybe.
right.
No, but they have decided in this type of college cases. Our college cases also, that has been decided in Dhaneswar Naik case.
Is it?
Privately managed institution, that is a judgment of this Hon'Ble Court. So, my lord, accept it. But there is a case. Why I am saying? Because this is also, as my lord have put it, that is also a correct point. Because there are 2 types of defense in this type of situation. Unlawful permission. Suppose I am a very powerful muscleman of that area. I didn't allow the person to enter into the institution. And he will go file the management determined. Can it be permissible? My lord, my answer would be no. But if I am the secretary of the institution or the authority of the institution, I prevent him without a termination order, she can. So that
me is correct.
That amount to termination, maybe. As per the judgment, my lord, I don't want to continue. But here is a case, my lord.
Yeah.
So this is the effect. Now, she filed an appeal. This was the appeal.
Her direction is pass appropriate order direction for reinstatement in my former post in English in Kalinga Women's College.
My lord.
Okay.
This is the prayer here. This was the appeal in pursuance to the resolution of the government. I have given to this. I have also filed it here. In that compilation, I have again it given.
This is filed pursuant to which government?
Yes, that is there. My lord, please. My lord, kindly see this compilation I have given. That is also in the rejoinder I have given. 27/3/1983 government notification circular. I have given it to the compilation, my lord, after end of this first page 12. Thereafter, my lord, enclosures. So enclosure number 1. 27/3/1983. In the book also it is there.
It is called a government order or resolution?
Government service to the government resolution. But this has got a statutory.
That's all.
value by the order of this Hon'Ble Court in one Arjun Charan Jana case, that will be at page 1088.
Resolution dated
27/3/1983. Page 1088 in the book, yes.
27/8/83.
83. Page 1088. Mine. I have given it, I am just reading out. Copy of the Astral Education Youth Service
Not
Department.
necessary. I go.
Sir?
Anybody discuss this? Nobody is.
No.
Skip on.
So now only one thing I will from that resolution that says,
Yeah.
if a person is terminated by the management of an unaided recognized institution, then he has to file an appeal within 30 days. That is the point of limitation.
But
Yes,
where is
sir.
the termination?
There is the termination. Well, I will show it. But here in this appeal, she has not disclosed that. She has disclosed in another order. I will show. So, my lord, here even if assuming for the moment, my lord, if it is 21/1/2007 is the date of termination, let us say it is hypothetical. So 31/2007 says by within 30 days, it is well within the permissible limit. 30 days. But it is if it is beyond 30 days, then my lord, the law will take its own course. Beyond 30 days not permissible because I have given the judgments also. If it is beyond 30 days, the administrative authority has no power to condone the delay. My lord have already decided in the Supreme Court that Popot, Beru, Govardhan, I have given that judgment, I will say. Administrative authority, that land acquisition case where the Hon'Ble Court has administrative authority.
They are very different.
I know, but they say quasi-judicial authority, the Hon'Ble Court has held, the quasi-judicial authority has no power to condone the delay. So here the director is discharging the duty of a quasi-judicial authority.
Authority under a statute.
That is in that is. But here in this circular, my lord, that has been taken on Arjun Jana's case, my lord, this Hon'Ble Court has held that this is a rule under Article 165 of the Constitution. So it is a for the purpose of this appeal. Because what happened, my lord? Unaided recognized institution, there is no service protection, there is no rule for them. This is the only circular. Once you become aided, the institution became aided. If my termination is there, then I can approach the State Education Tribunal under Section 10A of the Orissa Education Act 1969 or under Rule 2215 of that 1974 rules. There is a procedure. But from there is no procedure. This type of employees. So therefore, they filed an appeal. So now, my lord, under this, they have filed an appeal. What happened, my lord? Now I will take my lords to the appeal. What is now her case is this appeal was not disposed of by the director. Though notices have been issued up to 2010, thereafter no action was taken in the matter. So in 2018, she filed an appeal to the State Education Tribunal. So what she says before the State Education Tribunal is the appeal at that is at the rejoinder. I have given it page 53, but I have given it once again here. My lord will get it page 28. Page 28 in this compilation.
So according to you, an appeal filed, a time-barred appeal is no appeal.
No appeal.
Learned counsel for the petitioner submits a time-barred appeal filed by the employee at the level of department pursuant to government resolution dated 27/8/1983 is no appeal at all.
In view of the judgment of the Hon'Ble Supreme Court, I have relied 2013 10 SCC 765.
What was the case that was it? Service law.
Port Bihari, this is a land acquisition that I have told them.
Makes no
But
difference.
there are no judgment sold because this is the
That makes no sense.
yes, sir. But this is the judgment. But they have said that everywhere, if a quasi-judicial authority pass such an order, then that is there. But here is I am not so much.
That was which year judgment?
It is 13, 2013.
2000.
Bihiru, Govardhan and others versus Special Land Acquisition Officer and another.
The decision in support of this, even under the Land Acquisition Act, where policy content and intent of the legislation are very different, and therefore does not come to his aid.
Fine. So now my lord kindly come to that page 2. Even the other rejoinder, if my lord will search for the rejoinder, that will be in the second rejoinder to the final counter affidavit he has filed.
Yeah.
That will be at page 56.
What is that? 56?
That is to the final rejoinder. I file a rejoinder to the final counter affidavit.
No.
I have given.
They call it.
That
That's
is,
all right.
my
Now
lord.
we have
I
cited.
have given you once again. This is one, my lord. I am not there, my lord. What happened in this case, as my lord have put me rightly, whether this prevention is a termination, but there is a termination order. He had admitted, not I am saying anything.
Where is that?
That kindly see appeal number 11 of 2018. That he has filed before the State Education Tribunal. What he has supplied before this honorable court in another case.
11 of 2000
18. That is, my lord, I have given today's
compilation.
compilation, page 28, my lord. Running page, but that is there, my lord. After that circular, is page 21, thereafter 28. Annexure 2 by A, I have filed it in the takeoff. From that, I have brought it, one place.
Appeal case 11 of 2018.
My lord. Now kindly see, my lord.
In that,
Appeal, see what she has prayed and what she has pleaded also. And annexed. Kindly see prayer, my lord.
page number?
Page number, internal page 7, 35 page, my lord. Therefore, it is prayed that the Honorable Tribunal, my lord, got it. See, no, see,
35, which I am holding in this paragraph.
yes, please. That 28 is started, my lord.
That on the issue notice response.
Was the termination. The retrenchment order 25/2000 of the GP and principal of
Order taken 2 by 2000 of the GP. Whether
that is at page 39. Yes, unacted.
I'll come to this.
Yes, unacted.
Whether idea of retrenchment fits into service law. In labor law, fits into ICAP.
Paused in the word retrenchment, but the service is terminated. Or the order is annexed. She has annexed.
Where is that order?
That is page 39, madam. She has annexed there in the tribunal.
2 by 2000.
25/2000. That same thing is written.
Page number?
Page 39, my lord, sir. My lord was at 35, finally see 39. That is annexure 3 to that appeal. To Minati Patnaik, lecture in English, 25/2000. My lord got it.
Your service.
Madam, your service hereby terminated with effect of. This was some 9/3/2000. Since the events are suffering, so and so.
9/3/2000.
3. But 25/2000 is the order, but 9/3/2000, it is some cutting and all these things. So therefore, it is hard document. I have got it from the tribunal. I filed it then. But the letter says 25/2000. Signed it on 25/2000. And she has also challenged 25/2000. She has said it is retrenchment. But the order says it is termination. I have got my points.
Yeah.
So now, so her case before the education tribunal was, kindly see, ma'am, what she said. She has also disclosed to the tribunal that I have filed an appeal to the director. That order also she has filed.
This is annexure what? Termination order.
This is annexure 3 series according to her in that index. I have given the index, my lord. 3 series. This order, like it is, page 28, my lord, come back to 28. The index.
Yes.
That is the copy of the termination order 25/2000 and other orders. At the same time, she has also filed where she had tendered resignation. That order.
This 2/5/2000 order is filed, challenged in appeal of
11 of 2018 before the State Education Tribunal, Odisha, Bhubaneswar.
what is the explanation? Any delay, etc. Anything?
No, nothing. No petition. I filed the entire petition, my lord. Whatever the notice, I was a party there. Whatever the notice,
You were not made a party. You were a party.
I was party. I open number 4, response number 4. So, and another document she has relied upon in that appeal, my lord, her resignation.
What she was doing during all these years?
She was actually a principal of another institution. I have given it
During
annexure
the said
5.
period.
Yes. That she is now saying in 2005, she joined as a principal.
This is part of the document. When you-
Yes, I have filed it. That is, my lord, may kindly get it from. I have given it and she has given a reply. Page 6, page 63. But that is somewhat not legible. I have got a legible copy. But 63 it is there.
You are drawing salary also there.
This is the principal. This is a website. I have collected it from that institution website. But the principal of that institution has certified no, she was appointed in 2007, contrary to this document. And you see the tabular form on the next page. This is one.
This is what?
This is staff position, name of the content of this person's designation, contact number, name of the departments. And that institution, my lord.
That is the unaided institution.
Yes, madam. Engineering college, one engineering college.
College.
Chandrasekhar Institute of Technical Technology Management.
Do you deny this document?
No, what she is denying is 2007 I was there, not in 2005. That is denying. He is accepting that. And similar, the date of appointment that is there in the record. But the next page,
You have a bank account.
Well, I have it.
You produce a bank account of your client.
Well, I'll ask her to search.
That will show everything.
well,
The rest of the things will fall together.
well. So now, my lord, can
Because
you
only valid after 2007.
all right, ठीक है.
We'll have to leave.
Same period.
That's all. Bank statement can be maintained
Well,
50 years.
since you're not asking, I'll solve some.
So, my lord, can you see?
Produce it. Then why are you?
Oh, then
The whole case will be
keep it good. My lord.
If she they can get it elsewhere. When
End of
the
this.
question of
All this.
as being in employment at all everything it will fall apart. Costs.
My,
No, only
all the other points, my lord, I will tell next date.
Let it produce.
Let him produce.
That will
Okay.
be clinching everything.
I'll take only 1 minute then.
Yeah.
If it is a case manner. Whatever about that production of bank account manner, I'll certainly produce that. But here it's a case manner. She got appointment by manipulation of fraud. And all the records are found to be manipulated. And the director manner pursuant to Lordship's direction called that inquiry. She participated and found manner that all the records are manipulated.
Negative equality.
You were drawing salary through account.
Government, my lord, the government has approved my service.
You produce your bank account number.
Yes, I will read it. They are paying my salary from that account only.
Let us see.
I'll see. I'll show.
I'll show. Learned counsel for the petitioner submits that from the day one, she has been working in the college. School? College.
Higher secondary school now. Yeah, college, my lord.
College. With effect from?
From 4/5/2000.
4/5/2000.
4/5/2000. And her appointment has been approved. Why daughter dated?
Just saying.
So
Just
and that she has been drawing salary
from the state
the
tax.
prescribed pay scale from the state grant, and it has been credited to her bank account. Therefore, petitioner is directed to produce the statement of bank account.
Mm. 25/2/14, my lord.
Approval.
25/2/2014.
You were appointed on?
2000 because
It took 14 years for approval.
in private institution these are happening, my lord, in Odisha.
There are 2 appointment letters.
Or whatever it is there. You can
Salary.
salary. You cannot argue on negative equality. You first
Salary.
25/2/2014.
Therefore, he is directed to, petitioner is directed to produce the statement of bank statement of account, which reflects that she has drawn salary during the same period. Well, next paragraph. Learned counsel appearing for the contesting OP number 4 submits that she was in the employment of the very same college, in the very same post, with effect from 2007.
Sir, six.
No, my lord, 1996.
No. From 1996. 1996. And therefore, she is directed to produce her bank statement of account. First off, next paragraph. Non-production of the subject documents may result into heavy adverse inference being drawn against the party concerned. That's it.
Her other appointment, my lord, that 10/8/2005 in other institution, that account she must. That is important.
OP number 4 is also directed to produce, in which institution you were working?
Samantha Chandrasekhar.
Whether that institution is still for,
Yes, my lord.
we'll direct them.
Koraput.
The name of writer, producer, her bank account statement, which would show some amount being credited to her account from
That institute.
that institute. That
That college,
another
that engineering college.
that engineering college. Write down that name. Engineering college. First one. Next paragraph. The principal of the engineering college, so and so, is hereby directed to furnish the complete service book of OP number 4. And also state when OP was appointed in the said institution and how long she was in the service, and also the conditions of service, such as salary, leave, child was born,
You also direct that, let them produce.
availment of maternity leave, or such other things in a sealed cover, addressed to the Registrar General of this court. First off, registry to send a copy of this order to the principal.
Samantha Chandrasekhar,
Right now.
Institute of Technology and Management, Similiguda, Koraput.
Send it by speed post. Immediately. No, next paragraph. It is made it very clear to everyone that should any wrong or false statement is found in the information or document furnished pursuant to this order, the police investigation would be ordered in the matter.
Only one claim. The project is not acceptable. That impugned order of the law, whatever document that was the input, the file of the government from the day criminal, let that be covered.
We'll see, but let me place. There are two. No, I'm not afraid. There are two directors, man.
In the meanwhile, the government to produce the original records.
Appeal. Director of Higher Education, first appeal says fine. Director of Higher Education Odisha and Director Higher Secondary Education of Odisha. These are two. These two directors.
Which one you want?
Yes. I will direct both. Director Higher Education.
These things will be available at the Education Tribunal appeal also.
No, yes.
One document will be set for, then everything will be.
The entire original record.
Call for from the Education Tribunal.
That was there.
That is
That was a stroke is there with the Orissa Education Tribunal, Bhubaneswar. Termination. Well, first time. That's yes, the registry of the tribunal to facilitate implementation of this order, willing which the concerned officer may be personally summoned for being subjected to penal action.
Well, let me refer to that appeal number, so it will be facilitated.
Yes.
Appeal number 11 of 2018
11 of 2018.
in the tribunal. Yes, ma'am. Let the interim order to continue. There is an interim.
Interim order is there.
Yes, ma'am.
Interim order to continue.
No, that
But Lord, kindly fix a date.
which I am referring to, madam, that annexure 9 is the interim order. That inquiry, madam, which was conducted in 2024, would not be available in.
Now, if you give
Hmm.
your employment particulars,
Yes.
and if he gives his employment particulars, it becomes easy for me to send someone to the jail,
Mine.
because two persons cannot occupy the same.
Yes.
At least it becomes easy. Yeah.
I have already produced all the documents in my comfort.
You have produced all the
Management. Institution. Institution had two type of documents. I'll show it when I will argue.
Well, but case is not that simple.
Yes, my lord. That is correct. My lord, kindly fix a date, my lord.
Each and everything is well written, but you're not even.
By you,
16.
my lord.
After hearing. Become 16. That's that was John. Somebody said there is some urgency in the weekly list, na?
Yes.
Yes.
I have submitted, but Patnaik is not receiving the call. Item 82. May I pray Monday and supplementary?
Monday we have
Then only the supplementary. Only would receive. He has already collected the paper my lord of directors. Only that will produce one. I have my allegation is there, my lord. I have sought for suppose 5 questions to be answered, to be reevaluated. They have done 2. Just an example I am saying one. Exact number I am now. So now they have produced the report. If that is properly evaluated, matter ends there. So he can take charge. Only Monday or Tuesday. Before
Wednesday.
Fine. Obligations. 82.
Okay. Shift it to the subsidiary list. Yes.
Can you mention?
Yes.
List item 6.
In this case, my lord, only one point is before your lordship for consideration, my lord. Your lordship kindly see Annex 1, page 14, my lord.
Page 14. I think there is one. What is the matter? Just
Matter, my lord.
tell me. The light of that I will read these things.
For different post advertisement was made for different post, my lord. The petitioner duly applied, my lord. Pursuant to Annex 1, page 14. Thereafter, my lord, what happened under Annex 2, page 19, the petitioner was selected out of the selection list. Out of the voting selection list. My lord,
Which post was advertised?
Hindi teacher, my lord.
Hindi teacher.
My lord. I may be permitted to read page 19 and Annex 2, my lord.
Advertisement dated
Advertisement dated, my lord, 7/5/2018. Annex
2018.
Annex 1, page 14.
Which post it was?
Hindi teacher, my lord.
26/26.
You applied for that.
I duly applied, my lord. Annex 2, page 19, my lord. The following 19 numbers of candidates who have been selected from voting list for engagement on contractual basis in upgraded high school functioning under ST and SC Development Department in Kandhamar district are hereby
Selected from waiting list.
my lord, are hereby requested to appear before the office of the undersigned at 10:30 am on 30th October 2019 for counseling. In this letter, my lord,
What is the counseling after the selection?
my lord,
Selection is done on what basis?
on the basis of marks, my lord. On the basis of marks, my lord, page 20, my lord. Page 20, my lord, list of selected candidates from voting list, Hindi teacher, second serial number.
This list of candidates from waiting list, what is that? What is meant by that?
My lord, there is a district level selection committee. They have selected it.
They have selected.
Yes. They
But
come,
why it is called as a list from waiting list? List of selected candidates from waiting list. Means it's a waiting list.
waiting list. Let him submit, my lord, thereafter.
My lord, in page 20, third column, my lord, list of selected candidates from waiting list Hindi teacher at serial number 2, Pratibha Pusti, my name, fence place, my lord. What has happened? This was not communicated.
One second, you are not making your statement. You are not substantiating this.
My lord, page 20,
Page 20
my
of select list.
selected candidate from voting list Hindi teacher.
Select list dated
Determined 21/10/2019 called for counseling on 30th/10/2019.
Annexure 2.
Annexure 2, page 19.
You are at serial number?
At serial number 2 in the Hindi teacher list, my lord, page 20.
Pratibha.
My lord.
Yeah.
Only grievance is my grievance only is that, my lord.
Yeah.
I have not been intimated about this selection. Only limited grievance, my lord, not intimated about the selection, for which I was unable to remain present
On that day.
on that day. They are
Counseling you could not.
no.
Why you could not be there?
They have not intimated. They have also admitted in the counter affidavit that no recorded delivery was made.
Took place on which day?
On 30th/10/2009, page 19, my lord.
30th.
30th October 10th, 2019.
That letter did not reach you.
No communication was made to me.
They have admitted.
They have admitted delivery. They have admitted no delivery, recorded delivery was made, but it was circulated in the website, they have said.
It was circulated in the website.
To all.
All.
It was circulated by website.
Not communicated to me in my WhatsApp or message or.
The information was not given. It was placed in the website.
Did you say that in your advertisement that everything will be posted?
My lord,
Where have you stated?
I'm coming.
How she will come to know? Unless she was informed in the advance, saying that hereafter no postman will come to your house. Who will post these things? You have to look into. Where have you stated? Where is the cyber literacy? Cyber literacy in Orissa is low. You have said it, at least in one judgment it is said.
It is not there in the advertisement.
Now, then how she will know? She will be waiting for the postman.
Yes, but
And postman will never come to her door.
it is not there in the advertisement.
Brother, how they will assume that you have advanced so much that you will do everything in the satellite level? If there is indication, yes, we can understand. And the world is moving towards cyber technology, we can understand that. Unless that is indicated.
Well, they were also applied through online.
They had applied online is one thing.
Yes,
But you should say that for everything communication
shall
will
be
be
made through website.
online communication. Unless that is stated, how can you find fault with the candidate who is selected? That's the only point now,
Yes,
Mr. G.
but yes, I understand, my lord. Not yet, etc., etc.
The Hindi teacher, not some engineer, lecturer, we can understand what Hindi teacher will do online. I'll allow this petition.
No, nowhere it is written in the advertisement that they.
How they will know? This is what Apex Court said in that Aadhaar matter, that we are not that advanced to do everything online. Therefore, we are on the hard papers.
Advertisements were thrown online.
That should have been told.
Advertisement.
Hereafter, we will not know. Postman will come to your house. Everything you have to see the our web line, and you should gather the information. They would have done that.
In the advertisement, it is written saying that the copy forwarded to the district informatics officer NIC, Kandhamal, for information necessary action.
For him.
Yes, he is requested to display the advertisement in the district website for wide publication. That is the advertisement.
Correct. But how they will know?
It, so far as the result is concerned, my lord, it is not mentioned in the advertisement. Rather, there is a notification for counseling. It is not there in the. No way.
Yes. Take note. Kindly be seated. Vasant. Good. Pursuant to advertisement dated 7/5/2018, a copy whereof avails at annexure A1, petitioner had staked her candidature for appointment to the post of Hindi teacher. First time. She came to be selected along with others, and the select list was prepared and published on 21/10/2019 at annexure 2, wherein her name figures at serial number. First time. It is the grievance of petitioner that at no point of time the counseling notice was issued to her, and therefore she could not participate in the counseling that was eventually held on 30 October 2019, and as a result, she is denied equal and reasonable opportunity in the matter of public employment, which is violative of Article 14 and 16 of the Constitution. Next one. Learned, kindly be seated, Mr. Chief, kindly be seated. Learned AGA, Mr. AGA, appearing for the OPs, resists the petition, contending that all information was web hosted, and the fault lies with the petitioner in not accessing the same, and therefore the petition should be dismissed. First off, he also points out that when other candidates had appeared for counseling, there is no reason for the petitioner to remain away from the scheduled counseling, and therefore she cannot be permitted to take the benefit of her own wrong. First, so contending, he seeks dismissal of the petition. Next paragraph. Having heard learned counsel for the party and having perused the petition papers, this court is inclined to grant indulgence in the matter, in as much as in the advertisement dated 7/5/2018, whereby applications were called for online, nothing was stated that the further process would be only on online basis.
Well, no, your lordship is right. But in the annexure 4, page 23, there, my lord, last paragraph, your lordship may kindly have a look. I'm assisting him, my lord.
Yeah.
whereas the notice letter so-and-so dated 21/10/2019 of the District Welfare Officer Kandhamal Pulbani was published in the district website, wherein 19 number of candidates, including 4 number of candidates of Hindi teacher category, were requested to appear before the DW Kandhamal for counseling on so-and-so date. But no intimation has been given to the candidates by
Any recorded delivery.
Exactly.
Okay. You're more than fair. Really appreciable. In fact, there is one Lord Denning's judgment. How it related to state public prosecutor. It discussed the role of the public prosecutor in the matter of prosecution. Lord Denning said, all good points for and against should be brought to the notice of the court. The role of government advocate is also same. It is not to win the case. The object of government advocate is not to win the case.
This law is to prevail.
Justice to be done.
Yes.
In fact, Palkiwala addressed a letter to Soli Sorabji when he was appointed as a Attorney General. How Attorney General should function? He indicated there is a board displayed in the American Supreme Court, which says whenever a citizen emerges victorious in the legal battle, the government devises it. That's the way they do it. Yes. But in my court, every counsel appearing for the state is very, very fair. Everyone is so fair. Yes. What you have written now? He is inclined to. Only on an online basis. And that no intimation would be, no hard copy intimation would be sent to any of the parties. First time. In fact, in the letter dated 6/5, in the order dated 6/5/2023, at Annexure 4, issued by, who has issued this?
Collector Kandhamal. Collector Kandhamal,
Collector of Kandhamal Science District. Addressed to Kandhamal District. It is specifically stated as that. In that 1, 2, 3, 4. Para numbers are missing, but paragraph number 4. You produce it, okay? We'll produce it. First up. Next paragraph. The post applied for was a Hindi teacher. And not the professor of computer science. The prospective employer was the school and not an MNC, multinational company, or a cyber unit. First off, it needs no research to tell that bulk of our society is not cyber updated. First off, had the letter been put into the post box, comma, the postman would have delivered the same to the candidates. And on such delivery, the candidate would have turned to counseling. First. However, all that did not happen. And that constitutes a great error apparent on the record, face of the record. Apparent on the face of the record, warranting interference of this court. Next paragraph. Learned counsel for the petitioner is more than justified in telling the court that in days like these, when there is a rat race for public employment, no selected candidate would remain away from the steps to be taken for gaining employment, gaining entry to the employment. First, there is absolutely no justification whatsoever for denying appointment to the petitioner in terms of selection list. First, anything in variance would strike at the root of law, at the root of reason, and at the root of justice. First off. Next paragraph. In the above circumstances, this petition is favored. Which is that quashing?
Annexure 4 measure.
The writ of certiorari issues, quashing the order date number 2064 of 2067 SSD dated 6/5/2023.
Fine.
It relates to only you or others also.
Only him.
Means minor. Only petitioner.
Coupled with a writ of mandamus to grant appointment, or you have to conduct fresh counseling.
Fresh counseling.
Post there is post.
Because there is a list.
Two poster lying
Vacant
vacant.
list is there.
To conduct fresh counseling
By intimating.
by sending a letter in writing to the petitioner for the purpose of appointment.
And petitioner and other
Petitioner and the other candidates, if any,
waiting list.
whose names appear in the waiting list, for the purpose of appointment. First off, this exercise to be accomplished within a period of 3 months. 3 months. And complaint should be sent to the Registrar General of this court, failing which it is open to the petitioner to move an appropriate application for taking penal action against the errant officials.
Poster lying vacant, they are admitted in the counter. Para 5, 2 poster lying
One
vacant.
there.
Para 5 counter.
Last line you have said, na? And this court has noted from the record that the posts are still available. Vacancies in the posts are still available. Still available. Somewhere you have to fit it. All right. Thank you. Conducted very well. Yes.
Item 7.
Yes, doctor. Tell.
May I please your lordship, the matter is regarding the arbitrarily, illegally recovery of the amount from the petitioner who was working as a class 4 peon in a government high school.
Rafiq Masi.
After rendering, my lord.
Is it covered by Rafiq Masi?
Yes, my lord.
When-
My lord.
Has he retired now?
Yeah.
What was he?
She was rendering as a class 4 peon in a government high school.
June.
Yeah, my lord.
When retired?
Retired. CS. Uh, 27, 5, 36, 2023. 36, 2023.
23.
Yeah.
He retired on 36/23.
Yeah.
How many years of service he has?
27 years.
27 years.
Yeah.
When is the recovery order?
Recovery order, my lord, kindly have a glance on Annexure 5. Recovery order, copy of the letter number 10/6/2022 and letter number 146 dated 13/6/2022 for recovery. Impugn order. My lord, have a glance on Annexure 5.
Annexure 5.
Which is there in page number 22.
Great pay from beyond the rules. Yes, Mr. G.
My lord, there is a case where his initial appointment was on head of basis. The headmaster committed a mistake.
You take action against him.
My lord, thereafter, my lord, he was allowed to revise scale and scale all these things for the period of head of period.
Yes.
That period, government the DO wanted to recover from him.
After retirement.
It is before retirement, probably.
But my
Before
10/6/22. He retired on 36/23.
36/23, before retirement.
No order is issued that one. Did you give him opportunity of hearing?
No opportunity.
no opportunity has given to the petitioner.
Then actually recovery started with effect from which date?
Recovery started from February 2022, 10/6/2022, which is there in Annexure 5. Page number 20.
That scale was given on which date?
My lord.
The scale was extended.
2008.
Huh?
2008. Scale was-
No, October 2010. Huh? Come to Annexure 5.
October 2012. So 2008 pay scale, scale 2010.
It was, no. Come to Annexure 5. 10/6/2022. The revised grade pay from October 2012 to October 2017 and the salary from November 2017 to January 2022 is in the revised scale of pay rules 2017 was paid to you by the DDO of this school, which was beyond the rules as per letter number so and so 21 of District Education Officer Cuttack. According to your undertaking dated 7/10/2017, the fifth schedule, the excess salary drawn
Annexure
in
is
your favor will be recovered
DY3
of February 20.
that undertaking is the DY3 to the counter. My lord, he has approved earlier to this honorable court, which was dismissed. Thereafter, a writ appeal also preferred. That was also dismissed.
Not for recovery, man.
It was for what?
Regularization.
Regularization.
You had
It was not connected with
Yes.
the payment.
Thereafter, my lord, the excess penalties in the counter we have said, my lord, that before drawal of the excess, under the drawal of excess money by the petitioner, it was undertaken by the petitioner to refund back.
So that was in February 2022.
That was in 7/10/2017. Undertaking dated 17/10/2017 of the petitioner. Copy of the undertaking dated 17/10/2017 of the petitioner for return of excess money is filed herewith as Annexure D/3 to the counter.
So 7/10/2017. Here it is. 7/10.
7/10/2017.
So 7/10.
7/10.
Annexure D3.
D3.
Well, you have given undertaking also.
Yes, they have given.
But you have recovered without giving an opportunity.
Opportunity was not given, but after dismissal of the writ petition and the writ application
No,
for
that was for regularization.
regularization, my lord. Thereafter, my lord, the excess amount which was paid, it was
So how you decided it is excess amount?
excess because that period was ad hoc period. It was not a regular period.
My lord, petitioner served for more than 27 years.
No, we are not
On our
disputing.
basis.
We are not
There is
disputing
no-
that.
Not a single rupee of gratuity nor anything was granted. For that purpose, she had filed the writ petition and also the writ appeal. But it was
Dismissed.
dismissed. Quoting the example of Omaduri and others. But actually, basing on that judgment, many others, even rendering less than service than the petitioner, they have been regularized in this honorable court matter.
How much amount is excessively paid?
Lordship, I kindly ask the law to counter D by 3.
Fixation of pay.
D by 3 my counter.
D by 3.
It's a judgment given by Justice Panirai. Your Lordship may,
Not regularizing the services.
my Lordship may come to page 14, paragraph 3 of that judgment. Paragraph 3, no, sorry, it is not paragraph 3, third page, your Lordship may kindly come. They have mentioned that this said representation, that order number so and so dated 28/4/2001, rejecting the claim of the petitioner mainly on the ground that A, the Division Inspector of Schools Cuttack at present designated as DO appointed the petitioner and allowed her to continue in service in a non-existent post without prior permission of the higher authority. It is really ridiculous to the service of the petitioner for the reason for which she is no way responsible. The petitioner continued in service beyond the yardstick of the school. But when the petitioner has been continuing in service in an existing vacancy, how he could be stated that there was no existing post in the yardstick, my lord, beyond the yardstick. Is there an inspector of schools at the head of the and headmaster of the school, Baramba, paid the salary to the petitioner without authority and without prior permission of the government. It is also absurd to say that the headmaster's CIs were disturbed. So the petitioner allowed grade pay of rupees 1,500 and 1,700 as per ORSP rule so and so, which was not applicable to the petitioner as stated by the opposite party due to such action of the opposite party number 3. The petitioner is constant to approach this court.
That is also decided.
Yes.
What the court said.
Coming to that point, because it is very faintly paragraph 21, page 22 of the counter. The decision of regularization of service is a policy decision of the government. The prayer of the petitioner beyond the purview of the jurisdiction of the present opposite party number 3, who has already considered her case.
No, that was a case essentially for regularization of service.
For regularization. But
it did not have anything to do
with the
recovery as such.
Recovery, yes.
Firstly, 27 years he has served.
Yes.
She has served.
Yes.
Anyway, courts have denied relief. I do not understand. But it binds me. It binds me still.
But my lord, his continuance in ad hoc period, that period we have deducted, not otherwise.
No, but now.
After Rafiq Masih and that.
Other things. Though Rafiq Masih says after retirement, there is some indication that the lower officials.
Class 3 and class 4.
Class 3, class 4.
He is a class 4.
Admittedly class 4. No opportunity of hearing is given. No regularization is given to her. Having taken her blood and sweat for 27 years.
No, he was
Unceremonious
regularized
discharge.
subsequently thereafter.
Service is regularized.
Not
Not regularized.
That purpose, he had-
This is a perfect
He's not
case for
getting a
avoiding the
pension.
relief issue. Otherwise, injustice.
Lord Shripad disposed of it.
That's what. Right now.
ସେତେବେଳେ
Petitioner
appointment କରିଛି
having
ତାକୁ କରିଛି
as peon for a long and spotless service of 27 years, retired on attaining the age of superannuation on 30 June 2023. First stop. He or she is grieving. Kindly be seated. Kindly be seated. She is grieving before the writ court against the recovery order dated 10/6/2022, which reads as under. Observe. Fine. Next. Learned counsel for the petitioner submits that her client belongs to class 4 category, and therefore at this length of time no recovery can be made from the salary, pension, pension, emoluments. First, learned counsel, what's your name?
Anjana Misra.
Anjana Mishra. Vehemently submits that her client was unfortunate in as much as, despite such a long and spotless service, she could not secure regularization, her legal battles eventually having failed. And therefore, justice of the case warrants that no recovery should be effected. Next paragraph. Learned AGA appearing for the OPs vehemently opposes the petition, drawing attention of the court to the earlier rounds of litigation, namely WPC 39394 of 2021, disposed of on 20 September 2022, followed by writ appeal number 1362 of 2022, disposed of on 29/8/2023. First time. What sentence you should write to the contention of? The counsel also points out that the impugned recovery is violative of principles of natural justice, since no opportunity was given to her client. Thereafter, learned AG, so on and so forth. Learned AGA further submits that the question of granting opportunity of hearing would not arise in as much as even if one such was given, it would not have changed the outcome. First, he also tells the court that the principle in Rafiq Masi is not applicable to the case since it involved retired employees. First, next, having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter for the following. Number one, admittedly, petitioner has put in a long and spotless service of 27 years and peaceably retired from service on 30 June 2023. First of all, her earlier litigations wherein she has sought for regularization of service did not bear fruit, whatever be the reasons therefore, and they have attained finality. First, learned counsel for the petitioner is right in submitting that in the light of subsequent declaration of law by the apex court in Jago,
it is recovery of a party.
No, Jago is for regularization. Regulation. Jago, so and so. Hopefully, she could have been regularized in service. First up. This aspect also needs to be kept in view, since petitioner was unceremoniously sent home without granting the status which she would have acquired on regularization. First off, the state and its instrumentalities should conduct themselves as model employers, said the apex court in Bhupendranath Hazarika versus State of Assam. Next one. Learned counsel for the petitioner is right again in telling the court that recovery of the kind could not have been made without giving an opportunity of hearing to the petitioner. First off, the principles of natural justice are treated even by the apex court as sacrosanct in the light of Article 14 of the Constitution. First, no explanation is being offered as to why no notice was shooted to the petitioner before effecting recovery. First off, things have been done which even the East India Company of the bygone era would not have done. First off. Next point. Petitioner admittedly is in the class 4 category. First. In the costly days like this, when bread is costlier than the blood, comma, recovery from the salary or emoluments, that too in respect of an event that happened years ago, would not augur well to the rules of reason and justice. First term. Compassion is not anathema to the Constitution. First term. This needs to be kept in mind by the officials while dealing with employees of the low ranks of public service. First off. That is the inner voice of Apex Court decision in Rafiq Masi. And also there was one 2025 judgment.
There is a judgment.
Rafiq Masi is 2014 or 15? 14. Year 2014.
2025. No. How would a judgment is 2025 also?
There is 2025.
Yes, that is
has also come.
Thomas.
Thomas, Daniel Thomas.
Daniel Thomas. Thomas. Sorry. Next paragraph. In the, how much is recovered now?
Sir, 46,000.
Is recovered already. In the above circumstances, the petition is allowed. Semicolon. A writ of certiorari issues, passing. The Thomas Daniel is 2022. Thereafter, it went to Supreme Court. There is one more, 2025. Somebody said that. We have referred to that in one judgment. Ask someone. Okay. A writ of certiorari issues, quashing the impugned order of recovery, coupled with a writ of mandamus to refund to the petitioner entire money recovered from her within a period of 8 weeks. 8 weeks.
Lord, kindly allow some interest.
You are not entitled to retain the money itself. On that ground, he will go in appeal now. Sans interest. Sans any interest. First. However, delay will carry interest at the rate of 1% per mensum.
Sometimes more may be given because he is to get sanction from the government. That's why.
3 months we have given for refunding the money. Within 4 months.
That amount what he has told that 2 lakh some odd is subject to verification.
That goes to higher level for approval.
No. Yes. That may be subject to verification of that amount.
No, amount I have not said. Amount is for you to calculate. Whatever amount is recovered. That one. Now, when order of the recovery is to be, refund is to be made pursuant to order of the court, the question of approval will not arise. There is such a judgment. Simply they should obey.
But they are to obey their higher officers, my lord. They are to.
Suppose they say no.
No, they cannot say no because.
No, if they say no, then you mean to say that my order should go to the dustbin.
No, definitely.
Simple. Okay. Delay shall carry interest at the rate of 1% per mensum, payable by the payable to the petitioner. And the delay, the interest component may be recovered from the hearing officials of the department. Of no cost. Yes. Yes, you argued very well.
That will valid.
Yes. Can I return in a few minutes? Yes. Yes.
I'm hearing on behalf of Mr. Kisan Patnaik. This is out of town and it's for an adjournment.
My lord, in this case, I am for the petitioner. My lord and senior request me take up this matter on Monday.
Which year matter?
23 matter.
Monday we have.
Yes, my lord.
Only urgent matters. 1 week I have confined only for urgent matters. We'll have it immediately on 9th of October.
My lord, this is a selection process. One post is kept reserved. So I feel only 2 years already I am waiting for the.
Any one post is kept reserved?
Yes, my lord.
So nothing will happen to you.
So I feel taken up Wednesday. Monday or Wednesday?
No, not much. I'll immediately after application. Okay.
This entry order will continue.
Within 1 month. Yes.
The problem.
Item 9.
Here the case of regulation of class 4 employees, they are, take a please. They are class 4 employees working for 30 years, 15 to 30 years. There are 7 persons. One is died, the name has been deleted. They're in the Board of Secondary Education, Odisha. Vacancies are there. Recommendation was given by the board. But now in the plea that government had a notification way back in 93 that those who were appointed on DLR or NMR basis prior to 12/4/1993, there was a circular. So they have been denied regulation. Now, my lord, this Jago and all these judgments, my lord, have come. My lord, have stated that even outsourced employees are to be regularized. But they are regularly continuing. Recommendation in our favor that they are indispensable hands.
State has not filed counter.
State counter not required. They have rejected my claim, my lord. And litigation, I am fighting the litigation.
You are found.
And for the Board of Secretary.
Why do you worry about state? If you want your address are not required.
Senior is out of station.
And my problem, one of this petitioner, only one person. One of these
14, 10, 20, 24, 25 at the request of so on 14 we will have asked.
Yes, ma'am.
Anyway, it's covered by judgment.
judgment, yes. One of them will retire in the next month. Then he will not get.
Let us.
Fine.
Item 10.
This is retired headmaster, my lord.
Retired headmaster.
Retired on 31st May 2018, my lord.
(21/5, 2000). How many years of service he has?
He joined in 81, man.
81.
Yes, 1981.
81 to
2018.
2001, 2011, 30 years, 37 years.
Yes, sir.
Why are you here?
My duty pay salary with effect from 1/1/2016 to 17/3/2016 has not been paid. 2.5 months. 17/3/2016.
1/1/2016 to
17/3/2016.
that will be how?
2.5 months.
2.5 months salary.
And due to such non-regulation of my service and not paid the due to pay salary, I am not getting my regular pension because of they have not fixed my pay as per the ORSP rules 2008 and 2018, 17, minor. And for which I am getting much less pension. 2017, minor, much less pay I am getting, less pension. And when this is the second round of litigation, in the first round when this Honorable Court directed for consider the representation, they rejected, my lord, page 15.
Page 50.
1-5, man. Last para. Because there is a criminal case pending against him. Last paragraph.
What happened to criminal case?
Pending, man.
It is pending. What is the offense?
Offense is I have given a for the BEd certificate.
B certificate.
BEd, man. Bachelor in
B.Ed
Education.
certificate.
B.Ed certificate.
Any disciplinary proceedings are conducted?
Proceeding is pending, man. On the same charges. Criminal case as well as the departmental proceeding.
So there is a complete disciplinary proceeding.
My lord, counter is not filed.
No, that's all right. But how long your criminal cases will be there? At least 10, 25 years now. All judges like me will keep them pending. Nobody will get justice.
My submission is it is a duty-based salary, man. It cannot be withheld on the ground of a criminal case or a departmental proceeding, man. If it is a case of promotion, certainly the proceeding is pending. You will not consider as a promotion for promotion, man. But it is a duty-based salary. Because of non-regulation of certain 2.5 months, I am getting much less pension than I am entitled to, man.
Now provisional pension is paid to you.
Yes, man.
That
Much less.
is less than what is due to you.
Yes, man.
Yes, Mr. G.
Near about 40.
Promotion you can deny, I can understand. How can you deny the
Salary of 2.5 months, man.
The criminal case is pending. You can deny promotion. It's your prerogative.
Yes, my lord, let it come on Monday. I am not ready. We are not ready beyond item 10.
Immediately after vacation, I will post that. It's covered by judgment also.
I will.
Have you got that judgment?
No, man, I have not brought any.
There is one such judgment.
Salary cannot be denied.
Salary cannot be denied on the ground that criminal case is pending.
Recent judgments are there.
Yes. All these matters,
Next
I think,
week,
small, short point is involved.
Young friend, we are not.
Call this matter on 13th. Correct?
Yes.
40 cases are posted. 14. How many? 14. 12. This put this.
Okay.
15th of October.
October.
14th.
Yeah.
Beyond 10th, my lord, we are not ready. If anybody argues, let them argue. We shall give reply thereafter.
Okay.
Because today is Saturday, I thought up to item 10, it will be 9 item, it will come. Because batch matters are there.
Yeah.
So getting advantage of the holiday, some may come and argue the matter. Nobody has come, matters were adjourned.
Yes. Yeah, you are not ready.
Beyond
In the batch matter, are you ready?
no.
13.
13 has been adjourned.
Adjourned now. Next.
Item 11.
None appears. Call appreciation. Yeah,
Item 12.
same order. Up to 14, you are not ready.
Item 14.
Or any matter. Them only.
Item 15.
Item 15. This is a matter that the petitioner is appointed as a watchman in the year 1995. After serving more than 10 years, he filed a case for regulations. This Honorable Court directed for regularization and challenging that said order, the opposite part number 3 filed a writ appeal before this Honorable Court in division bench. And this one, writ appeal.
Why writ appeal? Any order was made in your favor?
No, sir, challenging, I have fled for regularization in this case.
They said consider your case.
No, my lord. Directed, no, earlier it has been rejected. Subsequently, my lord, it is directed to regularize from the date of passing that order within a period of 3 months. Subsequently, that order is approached by appeal, writ appeal, and writ appeal court, it has upheld the order of this honorable court.
Yeah.
The challenging that order, they approached the apex court. But apex court also it has upheld this, dismissed. But they, without giving the regularization with effect from the date of entry, they give a fresh appointment under a fresh new appointment under annexure
Annexure 8, dash 23. Days appointment they have. This is the sole grievance of the guest.
Who appears for the OPs?
Whereas the opposite part number 1 and 2 state as appearing. But the opposite part number 3, on which institution the petitioner is working, then another is appearing. Who is appearing?
But he is not here. Who is the answering OP? Answering the opponent is who?
Opponent not 3, sir.
3. Then 3 has to come.
Short words are since
Since 1 year. Yes, it is less than 1 year. 1 year, nearly about 1 year, 3 months, 4 months. Let us see, but he is not here. How to pass adverse order against him? In the presence of party, I can pass adverse order. In absence, I cannot pass. This was Saturday. It's not that we should not work on Saturday. That's another thing. Yes. Absolutely.
date we.
Let it come 2004, 24 matter.
No, sir. Since 95 is working at a harder.
On this matter on 2018. 2018.
Item 16.
Pardon, Vic mention.
Yes, Doctor.
Your Lordship, item number 14, yesterday only we have filed a wakalat number. We have instruction to appear for BMC. I have missed out. I'm seeking apology.
14.
Yes, Your Lordship.
You appeared in 14.
Yes, Your Lordship. For BMC, appearance may be repeated.
What's your name?
Katie Mudali.
So and so appears.
Yesterday only we have filed a wakalat.
Wakalat yesterday.
Yes, Your Lordship.
Show daughter's name. Print. Register to print name of sites.
Item 16.
16.
16 years already went.
16 gone.
Mr. Das had been to witness one.
Yeah.
That's happening in the morning.
Item 17.
Yeah. Name.
Item 18.
Yes.
My Lord, the matter is regarding non-revision of pension.
The opposite party is not there. Mr. Patnaik for the university.
Like for the university.
Yes.
My Lord. So university is on leave now. All after vacation.
My Lord, that petitioner is 74 years old and have bedridden. So at least in his lifetime, he should get back his legitimate claim.
I wish him Shatayushi. Come immediately after.
My Lord, what date? Next week may kindly.
No, next week not possible. Call it on 27th. Yes.
Published, man. Item 19.
24.
Item 21.
20.
The 2021, Mr. Counsel S.K. Das has requested me to pass over for the day.
21.
20, Mr. Mohanty,
21.
he sought adjournments yesterday.
After vacation, stop.
My Lord, I'm 21, my Lord. I'm for the opposite party number 4, my Lord.
But your friend is not here.
My Lord, the opposite party number 5, opposite party number 4 is going to retire on January to 26, my Lord.
26.
26.
Before that case will be decided.
Therefore, it also may fix a short date, my Lord.
Yes, short date. We call this matter
Counter has been filed, my Lord.
29. Yes. 2020.
Item 22.
Yeah.
Here, my lord, the pleadings are complete. Note of submission already filed. This is a case, my lord, regarding termination. If you also look at annexure 15, there was a direction by this Hon'Ble Court to cause an inquiry. I have filed so cause. In the so-called manner, I have taken a specific ground that the earlier manner, these cases were before the Orissa Administrative Tribunal.
Transferred.
Yes. When notice was issued, my lord, if you also kindly come to page 97.
Who is your opponent?
Opponent, my government.
My lords, maybe taken up any other day.
2810. That's the request. 810.
22 out of service. My juniors, my lord, they are continuing.
We'll also get the lead people.
Item 23.
I am first a petitioner, my lord.
Yes.
Petitioner's petition has been rejected. He is claiming the regularization of his service.
How many years of service he has put in?
Now 10 years. He is filed at the 8 years. Now continuing 10 years. This matter.
University is not before the court. Court has to go to university now. We have to give one lecture hall for court proceeding.
Now on 17th, your lordship has passed a 3 orders. That is a similar matter, but there is a group A, group B, but this person is a group C post.
But he is not here. But like generally he will be here now. He will not miss the court. After vacation.
That may be faced.
Date very difficult to fix now. I have fixed so many dates. We do not know whether the same bench or not, etc. Yes, if benches undergo change.
Any date of
this, it was very difficult.
Any date.
30th of October.
24.
24, in which both the sites are ready. Both the sites are ready.
May I pray one thing? May I pray one thing, madam?
Yeah.
Item number 60, a very small matter, relating to non-payment of salary.
Non-payment of
Salary, madam. The petitioner had met with an accident. Well, thereafter, he was operated in at Visakhapatnam. After coming, he gave the leave application. The leave application was not accepted. A so-called notice was issued. No proceeding was initiated, and he was imposed punishment.
Punishment of?
Now, punishment of censure and another.
Censure is a warning to warning punishment.
Thereafter, although I have worked for the whole of the month, he has shown the block development, block education officer, he has shown 0 attendance and he has not paid my salary. That is the case. Your Lordship had issued the notice, emergent notice, directing them to file their reply with regard to that, whether he has worked for the whole month or not. I have also annexed the document which shows, my lord, I have worked for the whole month.
What is that document? What is that document?
That document is at annexure.
What is that?
My lord, that document which my lord reveals, my lord, your lordship will get it at annexure.
Is it the attendance register?
Attendance register, my lord. From the attendance register, my lord, a report is being submitted for release of salary, my lord. My lord, that shows, my lord, I have worked for the whole week, whole month, and he has made it 0, and my salary is not being disbursed. My lord.
Who made it 0?
My lord, block education officer, my lord.
What the principal said, headmaster said.
I was the principal, my lord.
You are the principal.
Yes, ma'am. So may I pray, my lord, if your lordship, my lord, if my friend is ready, my lord, if not ready, my lord, your lordship may put it in the supplementary list on Tuesday, my lord.
No, this week we'll take only the new matter.
That's a very small matter, my lord.
Small, all right. But how many days salary you should get?
My lord, for the whole month, my lord, 1 month salary I have, that has been blocked, my lord.
That is how much?
My lord, that is around 75,000.
75,000. Yes, Mr. G.
It is. No, my lord, this is 60. In fact, it is with other brothers. They didn't think that it will reach.
On 23rd.
Item 28, my lord. Same, my lord. It's like 22, my lord. So on the same day, my lord.
23rd.
Item
34. Both are ready.
That's
34 is urgent, na?
to fix date only. I have nothing because they are saying that file is not done. But then I am seeing a date.
24.
24. 24, you put it on 30th. 30th of October.
Item 25. May I please your lordship.
25, ready? Who is your opponent?
On behalf of Mahabat, I prefer a Passover lordship.
Passover. Now 12:30. Is Saturday working is a difficult day. And that apart, you are organizing one function in the evening. This apart. Evening. Today evening.
Normally in Saturday, nobody is in a mood to work.
After vacation.
My lord,
Which year matter?
my lord, that is year of the 24, my lord. Though it is a 24 year of the 24, but this is a second round litigation, my lord.
First round litigation was of which year?
My lord, after litigation, 2019, my lord.
2,86,593 to be paid.
That is pending, my lord. And this is a covered matter, my lord.
Similar matter on 23rd. 23rd. Similar matters we have posted on 23rd. Yes.
Item 26.
26, brother. 26 also Mohanty.
No, it is with me. Petitioner is not there.
A very good advantage to you now. Call out application
27.
to enable counsel.
27, my lord, with that. Item 27 on behalf of Bundan Radha, I pray for adjournment after vacation.
Yes, after vacation. That's the regulation of petition.
Item 29.
29, my lord, I am for the petitioner.
Yeah.
My lord and senior Mr. Soy told that part of the day. So I will also can take on Monday.
What is the matter? Is it small, short matter? No. It's a complicated, little complicated. Date of birth,
I am challenging the input order dated 1/3/2024.
They have taken your date of birth as what?
Pardon, my lord?
You wanted the date of birth to be 5/3/1960. No, this is another matter.
Date of birth, my lord.
Huh?
Date of birth, 5/3/1960.
Date of birth.
Birth, my lord.
That should be the basis for retirement benefit.
Yes, my lord.
That's the case.
Yes, my lord.
We'll have it immediately after vacation.
My lord, kindly take on from Monday.
Monday, how many matters? Many matters are already posted.
Next week, any day, my lord.
70 matters are posted.
Man, next week, any day.
Wait.
Next week, any day, man. I pray.
How? 16 then. Yes.
October 16, my lord.
You bring that judgment.
Yes, my
For
lord.
the purpose of retirement, what is the date entered in the SSC certificate should be acted upon.
Yes, my lord.
That bring that judgment. There is such a judgment.
Yes, my lord.
Yes.
Ocean Court section and
I don't remember name, but there is Supreme Court judgment.
yes, my lord.
Yes. Yes.
So next week, I pray.
Item 29.
Set.
29 girl night.
Application.
29 see.
29.
29, Prabhu.
16 then. Okay.
Item 30.
That is for praying for the RSCP matter, that is for career promotion.
Those matters were
List. One order, your lordship will pass another order.
there. Similar matter.
Yes, ma'am.
Give copy to me. Have you changed the dates, sir?
No, but
Dates and other things, have you changed it? No, you have to change now.
I have corrected.
Huh?
Corrected, ma'am.
Yes, you correct everything and then give.
Pasumapatra is on the. Pasumapatra, it also hard. That was fixed to some of the debt.
No, this is for
No, this is for consideration to the number 3 will consider it.
only representation.
Man. Yes.
Same author. Date of the representation, you have to look into, right? This code officer. Yes.
Item 31.
University.
Yes, ma'am.
Utkal University.
No.
Some other university.
Agriculture University.
Agriculture University.
Counter, I have already filed.
They have the counter also.
They have also filed rejoinder.
Resigned also. All. Just have to go in there on the back. The enable counsel for the petitioner to comment on. Yes.
Item 32.
That request none appear for the petitioner. First week of November. First week of November is petition or up to what date? November.
Third or 6th and 7th, the working day. November, 3rd November, 6th.
Second week of November.
So,
Yeah,
item 33.
same one. None appear for petitioner, third week of November. That's our second week of November. Yes.
Item 34.
Same one. Second week of November.
Item 35.
You appear for 35.
I am the opposite partner 224.
You are opinable. None here, third week of. None appears for petitioner. No.
Item 36.
Same order.
Item 37.
Both the sides, any matter, both the sides are ready.
My lord, item 53, government has to file the counter.
4 weeks for filing of counter. Next.
Item 37.
No. It appears both the sides are conspired against this court. Anyway. Yes, post application. No, post application.
Item 46. I am for the opposite party. Krishna is not there. It was a matter relating to stay on the construction of a CNG station. My lord said, heard it. So it was for orders. Now it is in the after notice. Lord, may fix a date.
In the second week of November, we'll decide.
Lord, maybe because it was on orders, now it is after notice. 30th October.
My lord, item number 41. I am for the petitioner. My senior is just now served a copy of counter. Kindly fix a date for hearing.
Same.
My lord, interim order is there. That may
Interim order is there.
Yes, ma'am.
Call you in the second week of November. Interim order to make it. Okay.
40, your lordship, is there for the petitioner. Your lordship says last order that is 16/12/2024 states when supposed to take instruction and file counter affidavit to that regard. The matter pertains that I had applied for issuance of the caste certificate that was rejected on solely on the ground that I could not submit the ROR, your lordship.
Record of it. We had one similar matter actually. Mr. G had argued that. How ROR is concerned with the caste. ROR relates to presumption and other things. Independently, Madhuri Patil has to be followed. Petition 910. 2910.
Which item?
Item
40.
In the meanwhile, you file objections. No, is it not appealable order?
Which applicable?
Appealable order.
For the appeal that.
Appeal also rejected.
Yeah, Lordship.
All right. Yes, how is your health now?
Okay, Malik.
Blame.
After vacation?
Yeah, Lordship.
Okay.